Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
On March 24, 2018, Roel Gementiza Padillo was arrested during a drug sting operation by the Philippine Enforcement Agency or PDEA at his residence in Barangay Mantagale, Balingwan, Misamis Oriental. Acting on a search warrant, PDEA agents allegedly found over 51 grams of methamphetamine hydrochloride or shabu in 14 sachets hidden in a plastic drawer in Padillo's bedroom. Padillo was charged with illegal possession of dangerous drugs under Section 11 of Republic Act No. 9165 or the Comprehensive Dangerous Drugs Act of 2002. Padillo pleaded not guilty. During trial, the prosecution presented evidence showing that the raid was conducted with proper coordination. The search was witnessed by barangay officials and a media representative, and the seized items were properly marked, documented, and later confirmed by forensic examination to be shabu. For its part, the defense did not deny that a search took place, but raised questions about the credibility of the search and seizure. Padillo and other defense witnesses implied that the illegal drugs may have been planted. The regional trial court found Padillo guilty and imposed a penalty of life imprisonment and a 2 million peso fine and the corresponding accessory penalties under RA 9165. The Court of Appeals affirmed the decision of the RTC and denied Padillo's subsequent motion for reconsideration, prompting him to elevate the case to the Supreme Court. On what grounds may an accused secure an acquittal, and what are the consequences of such an acquittal? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 15th of August 2025, and today we talk about acquittals in general and what are the possible grounds for an accused to be absolved of a crime within the context of the case of Roel Gementiza Padillo versus People of the Philippines, GR number 271012, penned by Supreme Court Associate Justice Ramon Hernando, decided on October 9, 2024. And joining us to talk about this case is Court of Appeals Associate Justice Jaime Fortunato A. Caringal, member of the Remedial Law Department of the Philippine Judiciary Academy. Hi, Justice Jat. Welcome to the Supreme Court Podcast.
Hi, Attorney Mike. It's nice to see you.
And thank you for accommodating us in your office, Justice Jat.
Of course. You're welcome anytime.
All right. First off, Justice Jat, what is an acquittal? Does this necessarily mean that the accused is not guilty of the crime charge? He did not do any of the acts? What does it mean?
Basically, in its very basic sense, an acquittal is really just a finding of a court after trial that the state or the prosecution was unable to prove that the accused is guilty. So it really is a legal and formal certification of the innocence of a person who has been charged with a crime. Now, in our jurisdiction, what is required for a conviction is proof beyond reasonable doubt. Anything that is lower than that, the court must acquit.
And so that's why we hear there's an acquittal on the basis of reasonable doubt. But there are also acquittals based on the finding that the accused never committed any of the acts. Can we talk about these grounds for acquittal, Justice?
Okay, so there basically are two kinds of acquittal, and these all bear on the effect on the civil liability of the accused. So, if the acquittal is on the ground that the accused is not the author of the crime, this means that the accused can never be held civilly liable for the crime because he never did it. On the other hand, an acquittal based on reasonable doubt on the guilt of the accused means that his guilt has not been satisfactorily established. And because of this, the accused is not exempt from civil liability because the quantum of evidence required is only preponderance of evidence, which is lower than proof beyond reasonable doubt.
Mm-hmm. And Justice, there are also cases where the accused actually raised defenses as a ground for acquittal.
Yes.
Can you name some examples of affirmative defenses which the accused might raise?
Okay. To answer that question, we have to look at it from the perspective of what the prosecution needs to prove to secure a conviction. So basically, in order to secure a conviction, the prosecution must be able to identify the accused as the perpetrator of the offense. And number two, must be able to show or to prove the elements of the offense. Now, from this lens, the accused, on the other hand, may raise several defenses to seek an acquittal in a criminal case. The common and recognized defenses include denial or alibi, lack of criminal intent, self-defense, defense of relatives or defense of strangers, mistakes of fact, insanity or imbecility, lack of evidence or reasonable doubt, which is, I think, the most common defense, and violation of constitutional rights, and double jeopardy.
And in some of those cases, some of these are actually circumstances justifying or exempting circumstances under the revised penal code, Justice?
That's right. Self-defense, for example, defense of relatives or defense of strangers. These are, these are defenses that could be raised by the accused to justify that although they committed the act, they are still exempt from criminal liability.
And each of these, they also have requirements or requisites that you have to prove, right? Your
That's
elements that you can't just say, I did it out of self-defense.
Yes.
Right?
Yes. You definitely have to present evidence for that.
And there are also procedural grounds, Justice, that some accused might raise to secure an acquittal.
That's right. So an accused can also be acquitted on procedural grounds, primarily raised through a motion to quash, no? Like the lack of jurisdiction over the person of the accused, in case there was an illegal arrest, for example, a defective information, lack of authority, for example, of the prosecutor to file the information, or violation of constitutional rights, particularly an invalid search and seizure. Additionally, violations of the accused's constitutional rights, such as the right to speedy trial or due process, can be grounds or can be invoked as grounds for acquittal. You should note, however, that not all procedural grounds, if granted, will result in an acquittal that bars further prosecution. For example, some dismissals may be without prejudice if not based on the merits or not amounting to double jeopardy.
And Justice, there are some questions here as to when you can raise some of these grounds, because there are some grounds that have no time limit, right?
Yes.
You can raise it at any time of the proceedings, but there are also grounds that you can raise only before a particular stage in trial.
Before arraignment, for example, you have to raise defects already in the information. You have to raise the invalidity of the arrest, among others. So there are really some grounds that are time-bound. There are some grounds that you can raise anytime. Particularly grounds that affect constitutional rights, you can raise at any time.
Right. And so in this case of Padillo, what's interesting is that he was convicted at the lower courts, even the appellate courts, but it was the Supreme Court which actually ruled that there was a violation of his constitutional right. When we talk about constitutional requirements for the issuance of a valid search warrant, what should we keep in mind, Justice?
Okay, so for the valid issuance of a search warrant, the following requisites should be present. The first is that there must be probable cause. Second, the probable cause must be determined personally by the judge. Third, the judge must examine in writing and under oath or affirmation the complainant and the witnesses they may produce. Fourth, the applicant and the witness must testify on the facts personally known to them. And fifth, the warrant should specifically describe the place to be searched and the things to be seized.
One of these requisites, Justice, is that the judge must personally found to have probable cause the application before him or her. How significant is this finding, and should it be indicated in the records of the case that there was such an examination?
Yes, and actually this is the main problem in the Padillo case, because in the Padillo case, there is nothing on the record which would indicate that the judge who issued the search warrant propounded searching questions to the complainant and the witnesses. And these are crucial in determining the existence of probable cause against Padillo. And then furthermore, the records were bereft of any explanation why the search warrant was issued against Padillo and why the specific location for the search was identified or was chosen. So, according to the Supreme Court, these omissions are fatal to the search warrant's validity because there is a failure to establish that probable cause existed for the intrusion into Padillo's property.
And our listeners might be wondering, if this was the case, that the search warrant was invalid or there was an improper issuance of the search warrant, how is it possible that the regional trial court and even the Court of Appeals actually did not notice this, and that the Supreme Court can actually reopen and look into the issue? So this is really perfectly valid, Justice, that when you go to the Supreme Court, everything is opened.
Oh, yes.
Once on appeal.
Oh, definitely. Well, once a case is appealed to an appellate court, and in this case, in this particular case, the Supreme Court is free to look into every aspect of the case. And in fact, the Supreme Court may affirm, may modify, or may totally reverse the findings of the trial court and even the Court of Appeals.
And one interesting aspect also of this case, Justice, is that there was an issue here about the implementation of the search warrant. The search was conducted at night. Under what conditions can a nighttime search be valid under Rule 126 of the Rules of Court? And was that standard actually met in this case?
Okay, so you must be referring to Rule 126, Section 9 of the revised Rules on Criminal Procedure. I must state the general rule first. No? So the general rule is that the search must be served during the day, or during daytime. But the rules allow for an exception. And what is that exception? A search may even be conducted at night, provided that the application asserts that the property is on the person or place ordered to be searched. Now, in the Padillo case, the search warrant stated that the search may be made at any time of the day or night. But the Supreme Court in this case had no way to ascertain if indeed the application of the affidavits of the witnesses stated that the property subject of the search was on the person or in the place ordered to be searched. So there was no justification for the search to be conducted at night, or at least it was not in the records.
So even if the search warrant says it may be served at night, the records must be able to support why the judge ordered.
Yes, the records must be able to show specifically and justify why it can also be served at night. And that was missing in this case.
And does it matter, Justice, that after the search, there were really illegal drugs that were recovered?
Yes.
But in this case, that evidence was still excluded.
Yes.
Why was that?
Well, the evidence was excluded because they were the result of, number one, a defective search warrant. And because there was a defective search warrant, there was an illegal search. So these pieces of evidence are considered as, in constitutional law, the fruits of the poisonous tree. Under this doctrine, once the primary source or the tree is shown to be illegal or defective, in this case the search warrant and the resulting search, any derivative evidence or the fruits born out of it is also inadmissible. So even if there really was illegal drugs that were searched and then retrieved, because they were born out of an illegal search and a defective search warrant, they were still excluded from the evidence.
And what will be the impact of excluding the evidence, Justice? What will happen to the case if the evidence is excluded?
Well, the inadmissible evidence will not be able to serve or cannot serve as a basis for the accused's conviction. And because they cannot be used, and remember, in drugs cases, the drugs itself are considered the corpus delicti of the offense. Because the illegal drugs cannot be used as evidence, there will be nothing to prove the guilt of the accused, and the accused will necessarily be acquitted.
And there's this issue of the failure of Padillo to timely object to the validity of the search warrant and the admissibility of the seized items. But the Supreme Court said the objections were not waived.
Yes.
Why is that, Justice?
Well, okay. So as a general rule, any objections to the legality of a search warrant may only be made during trial, either by way of motion to quash the search warrant or a motion to suppress evidence. An exception, however, is when there is a blatant violation of the constitutional right against unreasonable searches and seizures. So the reason for this is that the protection of fundamental constitutional rights must take precedence over procedural technicalities. In this case, in Padillo's case, even though he failed to timely object to the validity of the search warrant and the admissibility of the seized items, the Supreme Court upheld his objections because the search warrant was void, no? And the Supreme Court said that upholding the validity of such a void warrant would undermine the constitutional right against unreasonable searches and seizures.
And even if the search had been valid, Justice, the court still found that Padillo's acquittal would have been justified as well because there was a failure to meet the chain of custody rule.
That's right. Well, the chain of custody rule, that's very prevalent in drugs cases. Now, but before we discuss the chain of custody rule, we first have to discuss the three types of evidence that is usually allowed, no, in trials. The first would be your unique objects. So like a gun with a serial number. That's easily distinguishable from all other types of evidence.
Right.
The second type of evidence will be your objects made unique. These are easily distinguishable objects with no distinguishing marks, but which you can make a mark so that it can be easily distinguishable. And then number three will be your non-unique objects, no, as evidence. So your drugs will fall under this type of evidence, no? Because drugs, they're very minuscule and they cannot easily be distinguished from other drugs, no? That are obtained from other accused, no? So safeguards such as the chain of custody procedure are in place to ensure that the drugs seized are the same from the accused, are the same as those to be presented in court, no? So by definition, when we talk about chain of custody, it is the duly recorded authorized movement and custody of seized drugs from the time of its seizure to the receipt in the forensic laboratory for examination, to safekeeping by the evidence custodian, and then finally to the presentation in court for its destruction. To have a conviction, the prosecution, especially in drug cases, must establish that each chain in the chain of custody, okay, from the seizure to the turning over to the investigating officer, to turn over to the forensic chemist, and then later to the submission of to the court, no? In Padillo, the problem was the Supreme Court noted that there was a break in the fourth chain of custody. In other words, this was already from the turnover from the forensic chemist to the court. Because what happened here was, okay, the drugs were transferred or turned over to the forensic chemist, but it stayed with the forensic chemist for 8 months. And then the problem was, they did not present the forensic chemist and the evidence custodians for in court to testify as to how they safe kept the drugs, how they handled it, etc. So for the Supreme Court, this was problematic.
Is there a need, because we know that the chain of custody is really crucial to be established during the trial, is there any justice that all of those involved in the chain of custody should be able to testify?
Yes. As much as possible, everyone should testify. Now, in reality, I was a trial court judge also. In reality, the parties usually just stipulate on the testimonies of some of the links in the chain, no? But as much as possible, we see this in jurisprudence, every link of the chain must be accounted for.
And any break can automatically lead to an acquittal, possibly?
I wouldn't say automatically, but it will bear upon, well, it will turn the tides in favor of the accused, I would say.
And can we say that it would create a reasonable doubt if
Yes.
that particular drugs was actually the very drugs seized from the accused?
Yes,
Right.
we can say that.
Right. So very, very crucial, that chain of custody. And we see this happening all the time, right? Many cases in the Supreme Court overturned or many accused acquitted because of failure to follow this particular
Right. I can also say that for the Court of Appeals, in a lot of our cases here, we also acquit the accused because of breaks in the chain of custody.
Right. And having established some of the grounds, Justice, for acquitting an accused, what would be the effect of the acquittal?
A judgment of acquittal is final, unappealable, and immediately executory upon its promulgation. So this is based on the concept in criminal procedure, the concept of what we call the finality of acquittal doctrine, no? And because it is immediately executory, unappealable, and final, the result is an accused who is detained is immediately released, or if the accused is not detained because of bail, he will no longer be subject to detention.
Right. And also, what about the civil liability, Justice? Is it something that can be determined because of the acquittal, or will that have to be threshed out in another proceeding?
Usually, the civil liability that arises from the crime will be threshed out in the same proceeding. No? Unless, of course, there are certain rules where the accused can reserve the right to hear it separately in a different proceeding. But again, it goes to, the distinction of the types of acquittal.
Right, right.
Because if the finding of acquittal of the court is that the accused did not do it, then there is no civil liability.
Right.
But if there is just reasonable doubt, then it may open the door to civil liability.
Right. Okay. Right. So, Justice, what lessons should law enforcement agencies take from this decision, especially regarding the issuance and implementation of search warrants?
Okay. So, the protection against unreasonable searches and seizures demands strict adherence to the procedural requirements and cannot simply be brushed aside in favor of the presumption of regularity, as law enforcement agencies are wont to raise, no? So, the lesson here really is that our law enforcement agencies should ensure that the requirements for the application of a search warrant are met and that the said warrant be implemented within the confines of the law and strictly in accordance with legal provisions.
And I should also ask, what about observance of the chain of custody rule also for the law enforcers?
Same. Law enforcers, I'm sure they're trained already to do this, but just to remind them, the law enforcers should ensure the proper handling of evidence and it's the proper transfer to the next chain.
Right.
And then until it reaches the court.
What about for ordinary citizens, Justice? What should we keep in mind?
Okay. Well, the lesson in this case is that private citizens are guaranteed by the Constitution with the protection of the privacy of our homes, no? So in other words, the state, through its law enforcement officers, cannot just enter our homes and conduct searches and arrests at will unless there is probable cause to do so and there is a search warrant issued by no less than a judge, no? Without these, we are all entitled to be secure in our private spaces, no? This has been the guarantee of the Constitution before and it remains to be a guarantee today. And we can see that the courts should be steadfast in their duty as guardians of civil rights by imposing or expecting a strict observance of these constitutional rights.
Right. And finally, Justice, just to close our discussion, what should be our takeaway from the acquittal of Mr. Padillo here?
Okay. The main takeaway is that again, the Constitution protects us, ordinary citizens, no, from any abuse of power. No? So, law enforcement officers cannot conveniently take procedural shortcuts no matter how incriminating the evidence is against the accused. They must faithfully observe the constitutional safeguards against arbitrary searches and arrests by the state.
All right. Thank you so much, Justice Caringal, for joining us today.
Thank you very much, Attorney Mike.
And to our listeners, if you wish to read the full text of the court's decision, please visit the Supreme Court website and e-library. Look for Padillo versus People, GR number 271012. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court on Thursday, August 14, 2025, welcomed the signing into law of Republic Act No. 12233, or the Judiciary Fiscal Autonomy Act, by President Ferdinand Marcos Jr. at the Malacanang Palace in Manila. Chief Justice Alexander Hismundo attended the signing, along with 11 other justices and Office of the Court Administrator Officer in Charge, Assistant Court Administrator Lilian Baribalco. The law strengthens the constitutional guarantee of fiscal autonomy for the judiciary. RA 12233 allows the SC to submit its original budget proposal directly to Congress as an attachment to the National Expenditure Program prepared by the Department of Budget and Management, or DBM. The law also ensures that the monthly cash requirements of the judiciary will be released automatically by the DBM without the need for additional paperwork or approvals. On Friday, the Judicial and Bar Council, or JBC, released the list of applicants for the position of Ombudsman to replace retired Ombudsman Samuel Martirez, whose term expired on July 27, 2025. The JBC also announced the schedule of interviews of the applicants, which will be on August 28 and 29 and September 1 and 2, 2025. The SC has upheld the subpoena issued by the Senate Committee on Women, Children, Family Relations, and Gender Equality, requiring former Bamban Mayor Alice Guo to testify in its investigation. The SC en banc, through the Ponencia of Associate Justice Japar Dimampao, dismissed Guo's petition challenging the subpoena and asking the SC to prohibit the committee from inviting her as a resource person. The SC emphasized that Guo's rights were not violated and the inquiry was a legitimate exercise of legislative power aimed at protecting the public interest and upholding the law. The SC found that the committee's investigation into illegal pogo operations in Bamban Tarlac was within its authority. Guo was invited as a resource person, not as an accused. Meanwhile, the Supreme Court has issued amended guidelines on the proper use of the terms qualified rape and statutory rape in cases involving child victims. The rule expands the scope of the term qualified rape of a minor and increases the minimum damages awarded to victims. The court en banc issued the guidelines in a resolution written by then Associate Justice Mario Lopez as it denied the motion for reconsideration filed by a man convicted of raping his 8-year-old daughter. The SC ruled that the proper term is qualified rape of a minor, resolving inconsistencies in previous jurisprudence. The SC issued guidelines stating that when the elements of both statutory rape and qualified rape are present, the correct designation is qualified rape of a minor. These guidelines apply only to rape through carnal knowledge, not to rape through sexual assault. The Supreme Court en banc during its session on Tuesday upheld the decision of the Commission on Elections, or COMELEC, to disqualify Matt Erwin Florido from running as representative for Quezon's 3rd District in the 2025 elections due to vote buying. The SC ruled that the COMELEC's findings were supported by substantial evidence. It noted that the gathering held in April 2025 was clearly intended to gain electoral support. The distribution of cash and other items was also not properly documented or liquidated, contradicting Florida's claim that these were campaign-related expenses. Finally, Chief Justice Hismundo highlighted that the modernization of the Office of the Court Administrator, or OCA, is a move toward a judiciary that is responsive, inclusive, and sustainable during a town hall meeting on August 11, 2025. Key reforms include the formation of a central OCA leadership team that will focus on strategy, policy, and innovation, and the establishment of offices of the Regional Court Manager in all judicial regions. Present were Senior Associate Justice Marvic Leonen and Associate Justices Ramon Paul Hernando, Samuel Garlan, Jose Maides Marquez, and Roel Villanueva. They were joined by officials of the OCA and the Office of Administrative Services. You are now up to date with the Philippine Supreme Court. I am Tiffany Double-Tran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, J. Rempilio, and May Sibal as researchers, Brian Ostrea, Don Ryan Balza, Victor Laranio, Lawrence Olanio, Austin Aliscad, and Bea Batung as audio and video editors, and Tyke Flores and Jerome Batumalake as web editors.